Anyone have any contract issues that they're dealing with off the top of your heads that we need to we can address here? I was in Phoenix at a speaking, or at the owners retreat, and a speaker was giving a presentation, and he speaks around the country, and he would ask, does anyone have any questions about that? And then he would wait, and what I thought was an inordinate amount of time, and he said, studies show that it actually is best to wait 8 seconds for people to respond to that question. Do you have any questions or anything to share? Because at around 7 seconds or 7.5 seconds, typically that's when someone will speak up. So if you see me waiting a little longer than I might normally, it's because of that. Okay, some things that have come up in the last few weeks. One had to do with fair housing and VA and FHA loans. When a buyer is getting an FHA or VA loan, there's a form called the FHA VA Amendatory Addendum. It kind of has some things in it. And you may have a property that that's going to have required repairs before it can get this loan and things like that. And the amendatory clause says, all that is allowed. And the only way for a seller to kind of not discriminate against an FHA or a VA loan if an offer gets presented with an FHA or VA loan is to, object to the FHA VA Amendatory Addendum. As our legal counsel said, a listing agent could simply have the seller inform them to tell the buyer's agent that the seller will not agree to the terms of the federally required document, and the seller will not sell to the buyer who must use that document. So if you are representing a seller and you get an offer on an FHA VA loan, be sure to read the contents of that FHA VA Amendatory Addendum. Make sure that the seller understands it. And if they don't want to agree to it, that would be a reason to object to responding to the offer. Let's see. We had a listing and our agent received an offer on the listing. The buyer requested $22,000 in seller credits that they are not willing to reduce. So they're stuck on this $22,000 in credits. They want to increase the purchase price to make up the difference. And but the seller and the agent are concerned that it will not appraise for this increased price. The answer, the solution here was to suggest a counteroffer that would allow for the commensurate reduction in the seller credit if price needs to be dropped due to the appraisal. So I think that kind of worked all okay. We came up with some language that price reduction is needed due to appraisal, seller credit will be reduced by the equal amount. So let's say in this case, it was the list price was $685. They wanted to increase it to $682 and take a $22,000 credit. The property comes in at $675. Then that $22,000 credit would be reduced to $17,000 because the seller wouldn't be getting that increased price. So that was an unusual thing that came up. Question, I guess we have not seen the Lake County Association of Realtors disclosure before, disclosure advisory. And our TC asked whether we had a preference for either the CAR version or the Lake County Advisory. And we're fine with either form. And if you are in Lake County and used to using the LCA disclosure advisory, that's fine. Just keep using it, and it works for us. So I think Cheryl's on here, and she had a question about because she handles REOs. She's been requested from time to time by the owner of the bank to file a notice to vacate to the tenant or things along that lines, or be named in the notice to vacate as the person to contact. And this is not good because then we take responsibility for the whole eviction process and any errors in that process. So it doesn't come up often, but that we're asked to notify a tenant to vacate, but it's not something we really want to do. So the seller, in this case, the bank, needs to find appropriate parties to represent them in an eviction proceedings. Okay, so the buyers sent a request for repairs number 2, removing the request for repairs number 1. Does that mean that they automatically rejected the purchase price offered by the seller in the RRR number 1? So, but the process here was the buyer made a request for repairs. The seller responded with an RRR, which included the price reduction. Then the seller came back with a request for repairs number 2. So the question is, does that supersede that RRR where the price reduction was in there? And yes, the RRR2 kind of obviates or takes out of play the RR that was given by the seller. So and they couldn't rely upon 2 different RR forms. The last one agreed to is the final one. If you have any questions along the way, just pop in, because I'm not looking at the screen so much for raised hands. Okay, so fire insurance advisory. We had a question about fire just in the sales meeting. This is from our legal counsel. Paragraph 12A6 of the purchase agreement advises buyers to investigate the availability of insurance during the buyer's investigation period, and advises the buyers to satisfy themselves as to all matters in the BIA paragraph 3.H, which advises the buyers to investigate availability of insurance early. If a buyer waives all contingencies up front, then there is no contingency if insurance is unavailable or exceedingly expensive. So this had to come about with the a buyer who wanted to make a non-contingent offer, but was concerned about getting insurance. So as Bill mentions here in 12A of our RPA here, down to it here, buyer's investigation of the property. 6, confirm the insurability of buyer and the property, including the availability and cost of flood and fire insurance. So if that buyer wanted to make a non-contingent offer, but still wanted to reserve that right, we'd have to kind of write a clause that added that contingency back in, that within, X numbers of days, 17 days, 15 days, 14 days, whatever, that the buyer shall confirm the insurer, have the right to confirm the insurability of the buyer and the property, including the availability and cost of flood insurance. So you be sure if you're making a non-contingent offer that, that's pointed out and added back in if you need it. That's kind of that one. Okay, so this was an interesting deal. I will stop sharing here for a minute. We took a listing and the listing agent listed the property for $500,000, and then the seller went about and put the property in, I don't know if it was on Craigslist or somewhere. They posted it for sale by themselves for what, $575,000. So I mean, we're protected in the sense that if they sold it, found a buyer at 575, we'd be paid a commission, and probably called in to work on that transactions. But our legal counsel said there are a number of problems with this situation, and it required prompt action on the part of our brokerage. First, the exclusive listing agreement gives the broker the exclusive right to market the property. Unless the listing agreement specifies the seller can also market the property on their own, arguably the seller is acting in breach of the listing agreement by doing something that the brokerage has the right to do. We need to enforce the terms of the listing agreement on this issue. Arguably, the seller can claim that by our inaction is allowing her to do the marketing, you're waiving your rights to enforce all the other terms of the listing agreement, included but not limited to the right to get paid. So if we allow them to violate one part of the listing agreement, it might, we might be saying in a legal sense, well, you can violate all the clauses in the listing agreement, including pay us in a commission. The listing agent needs to have an immediate conversation with the seller regarding the validity of our listing agreement and what it means when a broker is granted the exclusive right to market the property. Second, the fact that the seller is marketing the property for more than the amount specified in the listing agreement is a red flag. The red flag could mean that, one, the seller thinks the listing is too low, or she may not really know what the listing price is, contrary to, is, or possibly the seller is including something else in her personal listing that is not in our listing. Regardless of why there is a difference in the price, there needs to be an immediate discussion between the listing agent and the seller about the fact that there are two different prices being used to market the property, and this creates confusion in the minds of the public. Third, I'm uncertain as to what your agent is referring to as, okay. So we thought them might be taking, the seller might be taking unlawful acts that harm the agent. The only issue here is, does the seller really understand that she has signed an exclusive listing agreement, that the two parties, the broker and the seller, need to agree on the list price, regardless of who procures the buyer, wine country or the seller, or how much the seller ultimately agrees to sell the property for, she will owe a commission to our group, the brokerage. Be particularly careful if the seller is older. We do get into issues of potential elder abuse in cases like this, where sometimes the seller claims they didn't understand the listing agreement, they were pressured into signing the listing agreement, blah, 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 blah. So if you do have an elderly client, sometimes the agents will call me and we'll go over that and take extra steps to make sure that they're understanding, what, the process that's going to happen. And to the extent we might ask a relative or a son or daughter or something to get involved in assisting the seller with understanding the process. Okay, next issue. We had a closing coming up, and we'd asked the seller's agent and their TC for 2 weeks to provide us with documents, certain documents that they hadn't not yet provided to us. They did not respond to the multiple communications and asked which documents, even though the list had been provided numerous times, they should provide us with it. What happens in the event that they do not get these documents to us prior to closing? Well, it depends on what the documents are. If they're required by statute, such as the TDS or the AVID or the NHG signed off by the client, other forms that are required by statute, we need to have, whether we get them prior to closing or after, we need to have copies of those. There are certain other documents that are, non-statutory that if we don't get them, we'll still close the file, but we'll put into our notes that we requested those forms numerous times, and the buyer or buyer's agent failed to provide them. So we had another thing similar come up recently, that the buyer, we were listing agent, the buyer's agent filled out an AVID and misstated the name of the seller. I think it was Anderson, and they put in Alexander or something like that. And whether that was a kind of a fatal flaw that we needed to have corrected. And the answer is no, not really. As long as the proper address was referenced in the form, the typo in the nature of the seller's name or even the buyer's name was, we get by that and accept the form as long as the property is identified properly. We had a question about, eviction of residential tenants. And we still can't make any recommendations to sellers about dealing with their tenants. The laws still are complicated relative to COVID, and tenants' rights under state, federal, and local ordinances. So we really need to advise the seller to get qualified legal California real estate counsel that deals with landlord-tenant relations. And we have some to recommend if the need be, but we just can't make recommendations or assumptions about what type of notice a seller can give to a tenant to vacate because they're going to sell the property. The issue came up too. I guess it was related to what's called the Ellis Act. It's a state law that allows landlords to evict residential tenants to go out of the rental business in spite of the laws by local governments to compel them to continue providing the rental housing. It limits the ability of the current landlord or future owners from re-entering those units, rental units, into the rental market for a specified period of time. Various cities and counties have placed additional limitations on the process of utilizing the Ellis Act and on the ability of a landlord or a future owner to again rent properties that had been Ellicized, if you will. So the fact that the owner is taking the property out of the rental market may be allowed by this Ellis Act, and then they sell it, but the buyer that's buying it could not kind of put it back into the rental market based on that Ellis Act. So that was interesting, but nonetheless, we need to refer those potential issues to a qualified California real estate attorney dealing with landlord-tenant relationships. Okay, so now we have a mobile home, and the mobile home, the party we were representing the seller, the party representing the buyer is what's called a mobile home dealer. And the mobile home dealer is licensed to sell mobile homes. Not mobile homes that are deemed to be real property. Once a mobile home is deemed to be a real property, you cannot, as a matter of law, pay a commission to a mobile home dealer. So the dealer was asking for our portion of our commission, and we couldn't legally pay them because they weren't licensed under the DRE, and they were claiming, well, they're a mobile home dealer. So what we had to do was we reduced the commission and the price of the property or by the amount of the buyer's compensation, and the buyer could then pay the mobile home dealer as she wanted to, but we, as a real estate company, couldn't pay the mobile home dealer. Interesting. We had a buyer who wanted, or a seller, who wanted to have assurance that they could cancel the contract if they got into the contract and then wanted to cancel. Would the seller typically have a right in the RPA as it stands to cancel the transaction? That's a question someone needs to answer. Rob? Yes or no? Rob's not paying attention. He's on the phone. Oh, anyway, no, there really are no.
Sorry, I couldn't get my audio up.
What do you think? Does a seller normally have a right to cancel under the RPA?
I do believe yes, but I've never come across it before. Am I correct on that?
Anyone else want to venture an opinion? Curtis, you've been around this business a long time. Does the RPA allow the seller to cancel? Mari, anyone? Curtis put in the chat no. So yeah, the answer is really no. The standard RPA does not allow a seller to cancel the contract unless the the buyer presents an RR or something that the seller doesn't want to agree to, and they can reject the RR, but the buyer still has the right to close under the existing terms of the RPA without getting what they asked for in the RR. So if that is something the seller wanted, specific language would have to be put into the RPA that allowed for the seller to cancel, and it would have to specify within what time frame and for what reasons and stuff like that. You remember I advise us all against being creative writers when it comes to writing clauses that aren't standard clauses in the RPA. I don't like creative writing in contracts. So if you come up against something like that, let us know about it, and we'll likely get the proper language for that kind of an addendum from our legal counsel, and go from there. Similarly, a buyer, I'm sorry. Yeah, the buyer wanted assurance that they could get their deposit back. Well, there are a couple of places in the contract that says, I think actually still that paragraph number 12. The buyer has the right to, if they don't like the inspections, they have the right to cancel the contract. This is the big buyer's contingencies. And it says that the buyer shall get their deposit returned. Similarly, in paragraph paragraph 14, here the seller does have these rights to cancel. Here, going back to our other questions, seller right to cancel buyer contingency, but if in the time specified to the buyer doesn't perform and the seller gives them a notice to perform, then the seller may cancel the agreement. And it says the seller shall authorize the return of the buyer's deposit. And similarly with the obligations, if they don't perform under their obligations, seller gives a notice to perform, and the buyer doesn't perform, the seller can cancel as well. So the seller has cancellations, right? But if the buyer performs under all the terms, the contingencies and obligations, contract obligations, then the seller does not have a right to cancel. Effective buyer. So the buyer may cancel if they, don't find the property satisfactory, and it says then they shall get their deposit back. So I'm not finding the specific language right now, but that is the basic contingency. But I think it's here in B3. By the end, I'm specified over the however for disclosure, the removal of the contingency or cancellation of the agreement. And if they cancel the agreement, they have the right to get their deposit back. Though that language was in there, the buyer, wanted explicit language saying they'd get their deposit back if they cancel. So we added that additional language, even though it was redundant. Another thing came up recently, which was the buyer had removed all contingencies, but hadn't closed. The closing date had passed. So our buyer gave, our agent representing the seller gave the buyer a notice to perform rather than the request to close, demand to close escrow. So let's just go back here a minute and see if I have the demand to close escrow. Sort. Z. Okay. So the notice to perform and notice to the buyer to perform has 2 days. Is the default here. You can put longer, but the default is 2 days. I think what our agent did in this case, they just checked one of the boxes and said failure to close. So close escrow on time, something like that. But the demand to close escrow, the DCE, let's see if I have that in here. Yeah. The demand to close escrow is a bit different, and it calls for 3 days. So, and it talks about let's see, if you do not close an end of period specified, seller may immediately cancel the agreement, bring legal action against you for damages, or bring legal action against you to force you to buy the property. So this kind of doesn't, this form should be used if that's the case. If the buyer fails to close on time, you don't use the notice to perform, you use the demand to close. Because at this point, the deposits may be at risk, and the buyer would not automatically get their deposit back. Whereas with the notice to perform, if it's a contingency and the buyer doesn't remove the contingency, they would typically get their deposit back. If it's a demand to close escrow, the seller has the right to sue for damages and perhaps retain part of the deposit. We had a case come up where there were there are 2 different termite reports on the property, and the buyer could rely upon either one, and the seller, might have had one done and they're relying on theirs, and then the buyer gets their own and they're relying on theirs. So, that has to be somehow figured out, and to determine which termite report kind of would be correct in terms of assessing what might be requested in the RR and so forth. Rebecca, you have a question?
Unmute myself. Kind of dealing with this situation right now. Yesterday I received a cancellation of contract request after multiple RRs and RRs going back and forth. We just couldn't come to an agreement. They wanted us to do work that the seller is not willing to do. And the agent kept talking about one of the things they wanted us to fix was the furnace system. It's a 1930s house, same system has been in there the entire time, and they did inspections, and she had one furnace and heating and air company come in, and they assessed, and I actually have to look back at the report. I only have an estimate for cost and work that they said needed to be done or wanted to be done. Anyways, they said it was a health and safety issue. And so on our cancellation of contract, and the agent kept bringing it up, it's a health and safety, the seller's required to do this, and that's not actually true, but she kept saying it. She's also an out of area agent, so I don't know if it's different in the Bay Area where she's working. But anyways, on the cancellation of contract on line F, I don't know if you want to pull that up so we can all look
Sure.
at it. But on line under number 1, the first paragraph, it's not a demand to close escrow, it's the cancellation.
Yeah, right.
She wrote, as the reason per health and safety required by the seller, furnace is a danger and needs to replaced along with multiple health and safety issues documented. Now, I haven't had the seller sign this yet because I am concerned about that line.
They put it in here under other?
Under other, yeah.
Okay,
And so I actually did just speak to Randy about this, as well.
right,
He was saying that she's not a licensed contractor,
right.
so her making that claim is out of her league.
Yeah. Mhm.
And so I was just curious about your opinion on the matter. I've passed along my concerns to the seller and I'm waiting to hear back from them.
Mhm, mhm.
But I just don't want that on the permanent record when she's not even
No.
supposed to be saying that kind of thing anyways.
Right, right. Yeah, I mean, you would prefer to see this, A, probably is permitted by good faith exercise of paragraph 14B or 12. Probably 12, that they inspected it and they didn't like it, so
Yeah,
the buyer is canceling. Or you know, if you've both been negotiating and you're both canceling, then it would be per mutual agreement.
yeah, that's kind of what
Yeah.
well, that's what it should have been, because my last email to her was either do A, B, or we cancel.
Yeah,
And so they chose C, so we're both agreeing to cancel. So,
yeah, yeah.
okay. Thank you for clarifying.
Okay. Sounds good. Just a couple other things. Weekly practice tips have been, you know, a couple have gone out in the last couple of weeks. One was a seller who receives post-close of escrow buyer claims. And they typically the buyer will go back to their agent, who will come to the listing agent if we're the listing agent, and then we convey this to the seller. Agents are not qualified to handle post-close of escrow claims. So, I mean, we can assist in communicating back and forth between the parties, but we aren't the ones to kind of suggest a resolution or so forth. The Lake County offices that were owned by Marcia, the Coldwell Banker offices, used a firm called RERM. And I don't know, Cheryl, or I saw Jose on here earlier. If you ever use those contracts, but because you know, the firm actually required them in the each of their transactions up there, it was their risk management program, basically. So we just had a call this week with RERM, and we're exploring in detail what they have to offer. And it has some interesting stuff, because they do jump in and provide lawyers in the case of a post-close escrow buyer claim, if the seller had gotten the coverage, basically, that the RERM offers. So otherwise the seller has to deal with that on their own, and that may or may not be something they want to do. They're going to have to hire a qualified California real estate attorney if it's something they can't resolve themselves. So we can help in communicating back and forth between a buyer and seller through their agents, but not be part of the resolution per se. The one last week, I think, had to do with striking out and inserting new terms in a contract. That falls under what I just described as the creative writing process that we really don't like to do. We've had sometimes attorneys are principals in the transaction, and they kind of like to mark up and cross out clauses in the contract and stuff like that. And if that happens and it's given to us and it's all crossed out, you know, or our client wants to cross things out, we need to kind of look at that carefully, and, you know, get Randy and I to look at what's happening, and if we need be, we'll run it by our legal counsel. So again, avoid creative writing whenever possible. Okay, sorry I was long-winded, but I was trying to catch up. We want to do a more detailed look at AB 38. I know Yeah, I use Curtis says we need a new acronym for the California Qualified Squid. Okay, I use QURCA, California Qualified California Real Estate Attorney. QURCA, I call it squid. I like squid too. But yeah, AB 38, the training that Heather arranged, and I forget who it was, one of the NHD companies provided, and some of the folks weren't kind of fully happy with that. So we'll do a separate session on AB 38 and how our company wants to handle that. But the basic thing is the seller, we're going to require the disclosure in all transactions, whether it's a high fire zone or not. And the seller needs to check the boxes. They have to make the determination to check the boxes, so we can't check them for them. So that's kind of the bottom line. But we'll get into that in more detail in a future training when we spend some more time on it. All right, if there's no further questions, we'll wrap this up. I'll count to 8. All right, everybody. Thanks for tuning in, and have a good week, and give us a call if anything comes up, okay? Talk later. See you, Alejandro. Hey, you're in the window at the office. Did you see? Your photo's in the window in the Sonoma office. You're looking good. Check it out.
Oh, okay. I will see that. Yeah.
Okay. All right, everybody, take care. We'll talk later.
Have a good weekend.